and I'm very pleased to welcome our two witnesses for the second half of our proceedings. That is Clarissa Stoneham, who is the Financial Capability Inclusion Manager at the Hammersmith and Fulham Citizens Advice Bureau, and Ian Doolin, who is a partner at Charles & Hamlin's legal company, and I'm very pleased to say one of the country's leading experts on these issues of tenants' rights and security of tenures. So I think we're promised a very interesting and helpful session in this second part of our proceedings. We've got a lot of questions, so obviously we're looking for snappy questions and snappy answers as we work through our agenda this afternoon. Yeah. But let me begin, if I might, by just inviting Clarissa and Ian to introduce themselves, and then we'll get on with the question. Clarissa.
Don't think you touch it.
Good morning, everybody. My name is Clarissa. I am from the Hammersmith and Fulham Citizens Advice Bureau. We run two housing projects, one aimed at preventing homelessness, which looks at rent arrears and maximising people's income. And we run a very huge core service. We deal with roughly 10,000 inquiries per year from residents in the borough or people working or studying in the borough.
Ian Doolittle, I hope you can hear me, can you? I've lost my voice recently, so tell me if it's a problem. War introduction from the chairman, not warranted. But we do a lot of work with local authorities and with housing associations, and when you had one, we did a lot of work with ALMOs as well, up and down the country, and so I hope we'll be able to contribute to the Commission's inquiry this morning.
Well, thank you very much indeed, and perhaps I can begin by turning to Clarissa and asking her from the perspective of the Citizens Advice Bureau what you consider to be the social pressures on housing in the London Borough of Hammersmith and Fulham as they present themselves to you. Give us the big picture about, the social context for housing in this borough.
Okay, so in 2012, the Money Advice Service produced a report saying that people in London are borrowing more than ever for the first time to pay for the essential cost of living. So when you bring that down to this borough, Hammersmith and Fulham, actually what that means in reality is people are struggling against the rising cost of living, the limited incomes, and the fact that there is financial pressures everywhere you turn. So for example, according to Step Change, Hammersmith and Fulham is the rent hotspot in London. It has the highest rent arrears in the whole of London, and it's remained that way for some time. However, when you look at the fact that 40% of people that live in this borough have over 60% of their income committed to contractual debt, then you can understand why people are so limited in their ability to actually afford their rent and afford their housing payments in terms of service charges, contractual major repairs, etc. In addition, being a private renter is now a bigger indicator of being an unbanked household than for people living in social housing. So when you actually look at the ability of people to pay, coupled with the affordability issues, it actually does compound the problems that we are looking at today.
Well, Clarissa, that is really fascinating and a very important context for the work that we're doing. I don't know if any of my colleagues just want to pursue on the issues that Clarissa has raised there very rapidly before. Yes.
Are you able to tell us anything about whether your organisation gets any more inquiries from residents of social housing who are in council or in housing association properties? Any reasons?
I can't drill you down exactly that at the moment, but what I can say is we run a project called Roof, which is actually funded by the local authority. We work very closely with the local authority, and I wanted to add to the examples of good practice they spoke about earlier and providing the one-to-one support and intervention. That is aimed at preventing homelessness, but we offer that to renters, owners, occupiers and families because there is a lot of movement between people in and out of private renting, local authority and housing associations. What I would say is that the issues that housing associations and local authority tenants face are very similar. So again, it boils down to their income, their contractual debt, and their understanding of their rights. I think it's very easy for us to talk about what are tenants' rights, but if tenants are not aware of those rights and don't know how to actually go about having support or implementing them, then they can't do it.
Just for clarification, can you just determine what contractual debt is?
Absolutely. So contractual debt is things like mobile phone bills, insurance, mortgage payments, rent. So it's anything that is a priority debt. So gas, electric, water, council tax, and car payments. So in this borough, a very typical London picture is most people are paying weekly or monthly for their living rather than owning outright anything.
Very helpful, thanks. I'm sure we'll go back to some of these issues in due course. Let me now turn to the question of tenants' rights and security and tenure. And let me also repeat what I said in my introductory remarks, which I think possibly not everybody was here to hear, which is that the Commission's job is to look at the choices that are available about the future of council housing in Hampstead and Fulham, and to make recommendations. We will make recommendations to the council. The council will then, in due course, decide what proposal it wishes to put to tenants, and ultimately, most importantly, if it does come to a stock transfer, then it will be for tenants to decide for themselves in a ballot. So tenants come first, and that is absolutely right. But let me go to this. And let me turn to Ian Doolittle. If the Residents' Commission were to recommend a stock transfer, let me ask, Ian, why does a housing stock transfer have an impact on tenants' rights? And what is the impact on tenants who are secure tenants at the time of transfer?
Thank you, Keith. Yes, I'm very conscious of the sensitivity of these issues, and it's our job as a lawyer to make sure that if it were to get to that point, that tenants have the opportunity to look very carefully at the points for and against, and to ensure that there's an informed decision. The position is sensitive because at the point of transfer, tenants who are current tenants of the council, that is to say secure tenants, with tenancies under the Housing Act 1985, they become automatically assured tenants under the Housing Act 1988. That is simply by virtue of the change in the ownership of the properties from the local authority to the housing association transferee. Whatever form that transferee takes, and I know the Commission will be taking evidence in due course about the governance options that there are for the type of landlord that might be appropriate for you to consider in your deliberations. So whatever happens, if the properties are transferred out of council ownership, the tenants become assured tenants. So going to your question of the question on impact, the next question for tenants to consider as part of the offer that is made to them at that stage is to look at the tenancy agreement that is proposed. And the reason why many, but not certainly all, tenants who have been given this choice have said, yes, we will go for it, is because they have looked at the form of tenancy agreement that is provided, set out in full in the offer document, is that they are able to evaluate that with ITA, independent tenants advice support, and evaluate that and decide, yes, that is a satisfactory alternative to my secure tenancy. So we may go on, if the Commission wants to ask questions about that, as to what form that tenancy, that new tenancy, will take.
Right, thanks for that, Ian. I think actually we will want to drill down a good bit more on these questions. So let me turn now to Kim Shearer with her question.
Thank you. Ian, how does an assured tenancy differ from a secure tenancy?
Well, the key point is that I think we're being invited to move the microphone along. The key point is that a secure tenancy is in part a contract and in part a statutory right. In other words, that Parliament has set out in some detail what needs to be included in a secure tenancy agreement. It is open to a local authority to include a number of its own particular provisions in that secure tenancy agreement, but behind, if you like, those particular provisions stand a number of statutory rights which it is not open to the local authority not, as it were, to include. An assured tenancy works on a very different basis. It is almost entirely a contract between the the housing association and its tenant, and so that has weaknesses and strengths. The obvious weaknesses are that if you do not include the rights which statute has included in a secure tenancy, the tenancy is weaker as a result, because those statutory rights do not go into an assured tenancy automatically. The strength is that, of course, a contract is a powerful lever, so to speak, relationship between the tenant and his or her landlord. And an assured tenancy cannot be changed as to its contractual terms without the consent of the tenant. So there are those weaknesses, and there is that one important strength. And to embellish the answer a little, it is by using that strength that one can incorporate in an assured tenancy agreement at the point of transfer those provisions which would otherwise not be included. In other words, those statutory rights to do with improvements, repairs, and some issues to do with succession, the rights of family members, for example, to succeed. They are incorporated as a matter of as a matter of contract, not statute, contract, into the assured tenancy agreement, when they would be incorporated automatically by statute in a secure tenancy agreement.
Thank you. You did mention about succession, which I also wanted to talk about. So just to be clear, in an assured tenancy, you could write into the contract a different type of succession than that which is currently in a secure tenancy.
Yes, there are 2 points in there. One is that what would not automatically be provided for in an assured tenancy is the right for a family member to succeed, and that would be incorporated by way of contract into an assured tenancy. The other point, which is, I believe, an important one, is that, as we would put it, the slate is wiped clean at the point of transfer. That's to say that even if there has been a previous succession, which would usually mean there would be no further succession, if there has been a succession, then that is ignored for the purposes of those succession provisions. So in that respect, there is an advantage, at least as far as succession is concerned, at the point of transfer.
Thank you, that's very helpful. clarify this a little bit further, you could actually write in, for example, that you could have 2 successions rather than 1.
Yes, the point about wiping the slate clean happens automatically.
But in addition to that.
Yes, so in addition to the wiping the slate clean, you would invariably incorporate not just the right of a civil partner or a spouse to succeed, but a member of the family if there were not such a successor. But it is not unusual to incorporate a discretionary second succession. Sometimes, in fact, I think usually is the case that right of succession, that second right of succession, would not apply to that property itself. It would usually apply to another property, another suitable property for the needs of that successor, but there wouldn't be a guarantee that they would succeed to a tenancy of that family home. So to recap, wipe the slate clean, definitely one further succession, query a discretionary second succession, but not necessarily the home where that success, as it were, predecessor, so to speak, lived.
Can I just follow up on that for absolute clarity? A secure tenancy, which is what a council tenant has, is defined by statute and is a statutory right.
Yes.
An assured tenancy is defined by contract. What's stronger, Ian, a statutory right or a contractual right?
This will be a controversial answer, because I'm conscious on my left-hand side there may be some people in the audience who will say they do not, as a matter of, as it were, gut feel, like the idea of being a tenant of a housing association. I can understand that. But I think the answer, unemotionally, is that a contractual right is stronger than a statutory right for this reason. That there is an entitlement on the part of a local authority to change the terms, not all the terms, not those implied by statute, of a tenancy agreement, following consultation through a variation process. There isn't such a right for a housing association to change the terms of a contract. So an unemotional answer is that this is a lawyer speaking, short of emotional intelligence, who deals with contracts every day of his life, says a contract is stronger than a statutory right. But there will be people in the audience and who may or may not in due course be asked to express their own views on this, who will approach this in a very different way and say, would they prefer to rely on the local authority of whatever nature, whatever political hue, rather than rely upon a housing association. But anyway, you asked me for my answer. I'm a lawyer, that's my answer.
Well, thank you for that. That's really extremely interesting and something that we will obviously want to discuss and think about and consider in due course. We go on with further questions around these issues. I'm going to turn now to Paul, if you could. Paul.
Thank you, Chair. Can I ask, do assured tenants have the right to buy?
Right, well the simple answer is they don't at the moment, but we know, don't we, from the promised or threatened housing bill, which the new government has announced, that housing association tenants will get the right to buy, or if you read the words very carefully, equivalent levels of right to buy discount. And the smart word on the street is that it's conceivable that the government will adjust the arrangements for the right to acquire to give housing association tenants the equivalent to a right to buy. So the short answer is, at the moment, they don't, but if the housing bill is passed, they will.
Thanks, Ian. I want to follow up with a small question and a large one. The small question, going back to the response about assured tenants and the right to buy, can you just comment specifically on the arrangements that are sometimes put in place in a housing transfer in relation to secure tenants transferring and the right to buy? That's question number one. Question number two is, I'd like to invite you to go back to the response you began to helpfully give us about the new government's proposals around extending the right to buy. And as it were, can you, for all of our benefit, fill in both halves of the suggested policy that the government is putting in place, from what the extension might be and how it might be paid for? That would be helpful.
Right, yes, the small question. Anthony Mason questions are never small. This is about the preserved right to buy. So I answered Paul's question very narrowly in its terms, which is the right answer is an assured tenancy does not attract the right to buy. But on a transfer, there is something called the preserved right to buy. So that moves over as a matter of statute. There are some elements to the preserved right to buy which are enhanced contractually. For example, the right to buy for successors. But the short answer is that, to a short question, is that on a stock transfer, the right to buy is preserved statutorily and therefore is taken across by tenants of the council to tenants of the housing association. Can I go on to your larger question? Yes, there are indeed two sides to this proposal in the housing bill which has been announced by the government. The two sides are that on the one hand, housing association tenants will be given the right to buy, and I speculated whether that might be an enhanced right to acquire, levels of discount rising in this case I think from £16,000 to £103,000. Where that leaves the government's pledge to give the right to buy to 1.3 million as opposed to the 800,000, I think 500,000 have the right to acquire, I don't know, but let's leave that as it may be for the moment. How is it paid for? It is paid for, as well as indeed paying for a £1 billion brownfield site regeneration or new build fund. It's going to be paid for, the government says, from the sale of what they call expensive void properties. I think more properly described as high value. I don't know why expensive is in there, but a high value void properties. This derives from a policy paper back in 2012, which was concerned only with new build. And the policy think tank then said £4.5 billion a year would be generated from the sale of high value or expensive council void properties. And clearly this will matter a great deal to Hammersmith and Fulham. The criteria for high value properties vary from region to region, London being a region. But whereas some authorities, outer London authorities in particular, will find themselves below the threshold for the various bedroom categories, Hammersmith and Fulham emphatically will not. I haven't heard any figures, but quite clearly the requirement to sell these properties is a very material issue, and I'm sure will be borne in mind by the Commission if by the time you report we have further details. In another central London borough, and one can all guess that it will be areas like Westminster, Kensington and Chelsea, and Hammersmith and Fulham, but also Camden and Islington. the number of properties to be sold will be, could even be 30 or 40% of the void properties as they fall due. With the receipts generated thereby being in the tens, if not the single hundreds of millions of pounds. Because after all, the £4.5 billion, if that's a realistic figure, has got to come from somewhere. So I'm sure officers here, I know they are, will be looking very carefully at the potential impact. Please bear in mind, though, it is only about voids. And this is not about, as it were, dealing with properties where there are tenants, tenant security is preserved, but when a property falls vacant or void, the government will require the local authority to sell that property to, first of all, pay off the housing debt attributable to that stock, and then hand it over to them, the government, as I expect, to pay for the compensation for housing associations who lose properties under the right to buy, and secondly, to contribute to this fund. One final thought, though. I think there is, the jury is out on whether the numbers work. 4.5 billion pounds was generated or calculated in that policy exchange paper in 2012 on very different bases. 28,500 properties sold per annum rather than 15,000 properties sold per annum, and on an assumed void or vacant turnaround of 3.5, not as we think the current figures anticipate 7%. So whether we're looking at a set of numbers which have not yet been thoroughly worked through is for us to observe and speculate over the coming weeks and months.
Thanks for that, Ian. I've got Anthony Mason first, Anthony Wood second, and Shirley Colbert.
Thanks, Chair, and thank you. I simply want to, as it were, play back my newspaper headline, understanding of what you said, so we're all crystal clear about it. My newspaper headline understanding of it would be the proposal to extend the right to buy to housing associations will give rise to a need to compensate the housing associations because they're independent of government and their business plan relies on receipts of that sort. The money for that compensation will come from the enforced sale of council void properties as they become empty. That's my headline understanding. To follow that up, I think we'll know more as a housing bill is published by the government when? Sometime soon, presumably.
Within 100 days, if you believe politicians' promises. And the headline is absolutely spot on.
Okay, this Anthony.
Ian, just to clarify what you said before about high-value properties, I've heard different versions of how this is going to work. One version says that it will salami slice just the top value properties, irrespective of whether they're 1 or 2 bedroom. Another version is that they will look at each category from the highest number of bedrooms down to the smallest number. What's your understanding of
the thresholds, as they call them, are by bedroom, and off the top, I think it's £340,000 for a 1-bedroom property in London, through to 1.205 million for 5 beds and above. So you look at your stock bedroom by bedroom, type or size, and see if the threshold applies. In some London boroughs, as I think I indicated earlier, these thresholds will not be reached. It certainly will be, particularly in view of the figures that Mike was mentioning earlier, will be met in Hammersmith and Fulham, certainly are going to be met elsewhere in central London.
Well, I was going to say, 340,000 is going to affect a lot of tenants living in 1-bedroom properties in this borough.
Shirley.
Another one for you, Ian. Could you, just a couple of things. What I've understood you saying is that housing association tenants currently have the right to acquire
Yes.
So if you could clarify how that is similar or different from the right to buy. But also, I'm really interested by what you said about statute and contract, because I think, like a lot of tenants, I previously thought that by definition an assured tenancy cannot be as strong as a secure tenancy. And what you seem to be saying is it is, if it's written right.
Yes.
Related to that, could a future government weaken secure tenancies? So, for instance, they're bringing in rules now to force councils to sell properties. Could a future government decide to make secure tenancies less secure, or are they legally prevented from doing that?
Right. The first question was about the right to acquire. Currently, bearing in mind all that we've just been talking about in relation to the extension of the right to buy to housing association tenants may make this answer irrelevant, but the current discount in London for the right to acquire, and these are properties built with public subsidy, with public funds, is only £16,000 as opposed to the £103,000 discount under the right to buy. So that's why, particularly in a stock transfer context, one would mention the right to acquire but focus on the right to buy. As to the question of contract, yes, I stand by what I said earlier, but with all those caveats, because I can feel eyes boring into my back and saying, you must be joking. But if you get the contract right, the contract, in my view, is stronger than a secure tenancy which can be varied by a local authority. This, however, let me emphasise, is a matter of trust. If you trust your local authority, and after all you have the opportunity to elect, plenty of people in the room got the opportunity to elect your local authority, you will take a great deal of comfort from that. And so trusting the landlord, your local authority, is perhaps, as a local authority, is perhaps easier than trusting a housing association, because they are a social housing business. They're an independent organisation, as Anthony reminded us of in a different context a moment ago. But, you know, they're registered with a HCA, Homes Communities Agency. They are, many of them are charities and have independent and tenant board members on their boards. So I'm not going to get into a debate about which is the better organisation. There are plenty of arguments to be said in favour of housing associations for those reasons. But I do know that local authority tenants trust their landlord and leave the matter there. And can I just say one further thing? Very often stock transfer results, if that's the right expression, turn on this issue of trust. And I can understand that entirely. So trust is terribly important, and I'm trying to bring my limited emotional intelligence to bear on this issue. The last point is, could Parliament weaken a secure tenancy? The answer is yes. Parliament, of course, is supreme. It could decide. So far, it has encouraged, more than encourage, I think some local authorities think in terms of flexible tenancies. We had an explanation earlier, didn't we, from Mike about 5-year tenancies. But the interesting thing there is that the absence of compulsion. So that the previous administration saw merit in the 5-year flexible tenancy regime, and the new administration is proposing to revert to that earlier tenancy regime without, or not in the same form, that flexible tenancy structure. But the short answer to your question is yes, Parliament weaken secure tenancies, can weaken assured tenancies. And to strike perhaps a controversial note, one of the supreme ironies, I think, of social housing, that housing associations, with their ability to create strong contracts with their tenants, have been using, and that's where a lot of private finance has been generated as a result, have been using an assured tenancy structure regime introduced in 1988 in circumstances where it was thought to be of real benefit, not to the social housing world, but to the private sector, to provide, in the case of assured short-hold tenancies, certainty for landlords in their dealings with tenants. So it's odd that, if you like, to inject a slightly political note, a Tory measure has been adopted for social housing purposes.
Can I just, let me just turn to Clarissa at this point, and somewhat on this theme of assured versus secure tenancies. You said in your initial statement, Clarissa, that the CAB obviously deals with tenants from both housing associations and from the council. It is often said that housing associations are tougher in dealing with their tenants when it comes to rent arrears, when it comes to antisocial behaviour, than councils. Has that been your experience?
I don't think they're tougher. I think they might be more efficient. So they recognise, and I don't mean that disrespectfully to the local authority, I think they recognise and have thresholds that are a lot lower than the local authority. And just to add to this point here and answer you, Shirley, I think in terms of assured housing associations providing contractual tenancies, there has also been a lot of housing associations merging, and that in itself may have an impact on the contractual security. A couple of housing associations recently have been thrown into, they've had audit issues. Their board, has been under question, under scrutiny, and I think those things also need to be looked at contextually. Obviously, you're looking at things contractually, but I think there is a context to recognise as well, particularly with the difference between right to acquire and right to buy. It's fine to have a right to acquire, but who can afford a right to acquire, particularly in one-bedroom properties in the three most expensive boroughs in London, Kensington and Chelsea being the most expensive borough in the whole of Europe. I think that we need to, in terms of protecting tenants, recognise that is this a reality? Rights are one thing, but reality is another. So just to add to your point, Chair, that there is a difference, and there is a difference in the way those inquiries come about, but we see housing associations dealing with them differently as well. I think they have more resource to deal with it. I think they try to look at it in terms of a spectrum of severity rather than just a black and white issue as well. I hope that answered it.
Is that a good or a bad thing?
Pardon me?
Is it a good or a bad thing that housing associations tend, in general, to deal with these issues in a spectrum rather than, as you say, a black and white issue?
I don't think it is a good thing, actually. I think that the tenants of housing associations are left slightly less protected because that contractual, enforcement bears down harder on them. I think there's less leeway for them particularly in terms of finance, in maximising their income and getting grants and support. There's a lot more recognition for those in local authority properties rather than housing association. I think housing associations front end their work in the sense that they do provide probationary tenancies. They're a lot stricter in the way they assess their affordability, antisocial behaviour, looking at landlord references and things like that. And I think what that does is then gives the housing association more recourse when it does come to looking at contractual requirements of that tenancy agreement.
That's very Steve. Andrew.
Hi there. My question is, if we
Well, it looks as if it's back to me. Yes, I think I'm invited here to talk about the way in which a tenancy agreement is created on a stock transfer. And I think I already indicated at the beginning that this would be worked up in association with the independent tenants advisor and tenants groups generally as a proposal in the offer document. In other words, taking advantage of the ability of an assured tenancy to create contractually a set of conditions, terms and conditions which mirror those which are available to secure tenants. That offer document would include a full tenancy agreement. In other words, tenants would be invited to look at that tenancy agreement and conclude whether or not it provides the same level of comfort and security that their current secure tenancy does. And that's how one would convert a largely statutory secure tenancy into a largely contractual assured tenancy on the occasion of the stock transfer.
Shall we want to show it now?
It's a similar question to what we asked in the first part, but sort of asking you to do it. You partly probably also covered this already. But do you think, in terms of enforcement of tenancy agreements, there are any differences in your experience, and are there particular areas of good practice? And something that occurs to me is that this is about tenants' rights on both sides. So tenants who, obviously we don't want tenants evicted for no good reason, for instance, but we also want tenants who perhaps are subject to antisocial behaviour, harassment, etc., want their rights protected. So perhaps taking into account both sides of things. Any differences you're aware of? Both of you.
Of course, Clarissa will, I think, offer a more interesting answer than I do. I can certainly answer very briskly that the grounds for possession which are available to a landlord, whether local authority for secure tenants or the housing association for assured tenancies, are the same. So the terms are the same on either side of this divide, so to speak. And they were recently changed last October, I think it was, to incorporate more elaborate provisions, but those provisions are the same for secure and for assured tenants. But whether on the ground, bearing in mind what Clarissa has just been telling us about the way in which housing associations go about enforcement and dealing with their tenants, I leave Clarissa perhaps to comment if she can. Is that a hospital pass?
That's fine.
In rugby parlance.
Oh gosh, I think it's a really interesting question that you're posing, and I think there's two sides to it. It's how a tenant identifies themselves, and then it's how the local authority or housing association identifies the tenant. And I think if you can balance that, then you can look at the kind of recourse in the way that either local authority or housing association deals with the tenant. In short, I don't think there's a simple answer. I do think that kind of core issues are the same for tenants of both local authority and housing associations, and that is fundamentally around affordability and the kind of their employability, whether or not they're able to fulfill their contractual requirement right from the beginning. And I think that does actually go back to the kind of statutory rights that sit behind a secured tenancy as opposed to an assured tenancy. So in short, I don't think there's a tangible difference in the rights, but I do think there is a difference in the way that they present themselves, that the issues present themselves. But having said that, we do get pretty much equal amount of inquiries from housing association and council tenants. But again, it's how those tenants identify themselves. They don't come to us and say, I've got a problem with my housing association or the local authority. They come to us and say, I'm in rent arrears. You know, I need help because I'm undercrowding or overcrowding. And I think the way they identify themselves often determines the trajectory of the help that they're offered or the punitive measures as well.
So just follow up on that, obviously the rights kind of devolved out from the top, if you like, and the structure. But the interface that tenants have is at a lower level. It's housing officers and then possibly with other specialist teams. How much then is it about the values and the effectiveness of the individual housing officer teams, irrespective of what kind of organisation it is, in your experience, Clarissa?
Well, housing associations do operate for money. I mean, and they are, each housing association has a different geographical footprint and therefore different identity and ethos in the way they operate. Some are very geared towards families, some are very geared towards single occupancy. And I think fundamentally, if they're there, you know, they're selling properties as well as, housing associations, but they, I think the resource that they have through the finance that they generate in turn means that they're able to offer something quite different to local authority. Local authority, on the other hand, work much more in partnership with the voluntary and third sector. So I think that that level of support is more equitable and more equal for the people that access it. I think housing association tenants are a little bit at default because it is all dealt with in-house. So even though it's more beneficial in terms of early intervention and support, etc., I think there is less support in a wider context. That's the best I can
Okay, I
answer.
think you had something.
Sorry, you want me again?
Yes.
You said that grounds for possession are the same for both secure and short tenancies. Now, I know that isn't exactly true because there is a mandatory ground for possession, ground 8, which is obviously part of short tenancy but not secure tenancy. So my question is, again, going back to what you were saying about if you're writing a tenancy agreement, you can presumably write these things in or out. Just to confirm that you could, if you were writing a short tenancy, put a clause in that tenancy saying the ground 8 wouldn't be used. Would that be correct?
Yes, I hope I can clarify that when I said the grounds for possession were the same, I was talking about antisocial behaviour. I was not talking about all grounds for possession. Kim is absolutely right. There are significant differences between the grounds for possession available to a local authority landlord as opposed to a housing association landlord. And in broad measure, all the grounds for possession available to a local authority are, to a greater or lesser degree, discretionary. That is to say, the court is not required to give possession when the facts as stated in that ground are established. They have an overriding duty to look at the facts of the case, for example, to see if there is suitable alternative accommodation or other criteria which they are required by statute to bring to bear on the issue. So let's be absolutely clear. I'm saying ASB grounds are the same, but I'm not saying all grounds for possession are the same. And the difference is that assured tenancies have some mandatory grounds where if you establish the facts, then the court has no discretion but must grant a possession of the property. And that is what, as you hint, happens on stock transfer, rather that, as it were, that issue is addressed. And in very simple terms, including ground 8 for lengthy arrears, that is written out of the stock transfer tenancy agreement. So that it is possible to say, because of that change and other changes which knock out those mandatory grounds and leave the housing association relying on discretionary grounds only, that the terms of the tenancy agreements mirror one another.
Right, Anthony.
Ian, I think the next question perhaps goes back to the heart of why this commission's here and why the current administration made a manifesto commitment. And this is to do with really relevant. Can you give some idea? I think we're all aware that there are major issues
Yes, so just to be clear about my answer, this is an answer to do with secure tenants of the council, not in the context of stock transfer. Well, it goes back to the point about grounds of possession, that it is necessary, whether the order is to be made on a discretionary or a mandatory basis, as we've just been talking about, that except in one very important respect, you have to establish a ground for possession. And in the case of a secure tenancy, you have to, or you would, in the context of redevelopment, be relying on either ground 10 or ground 10A of the Housing Act 85 to establish that you were entitled to secure possession of a secure tenant's home because of a planned redevelopment. But the very important respect in which that is not the case is the availability to the local authority of its CPO, compulsory purchase order, powers. So that in addition to, or alongside, or on its own, a local authority might decide that it will secure possession of the homes occupied by tenants and indeed leaseholders by use of CPO powers. So that's the short answer, and I'm terribly conscious that this is a sensitive topic above all else in Hammersmith and Fulham.
Can you clarify a bit under what grounds can they issue a CPO? I mean, how how can those grounds? Is it possible to challenge those grounds? And how is it possible to challenge those grounds?
Well, I'm sure people have been working through the process because they're conscious that a particularly important CBO is in prospect. But there are 2 points to this. One is the basis of the CPO, and the second is the process. And I'm conscious of time, but in short measure, as to the answer to the first question, there needs to be a scheme. In other words, there needs to be a realistic prospect of a development taking place and what that development is going to be. And in the second place, as to process, there is the well-known opportunity for objections to be made in response to notices and the possibility, indeed in some cases, the requirement to hold a public inquiry. So those are the 2 key elements of any CPO process.
Thanks, Ian. We're beginning to come to the end of our proceedings, but I know Sophia has a further question absolutely arising from your last answer. Sophia.
Are there any ways of strengthening a secure tenancy in this respect?
Yes, and this is sort of holy grail time. Wouldn't we all like to be able to say a solution to some of the difficulties faced in Hammersmith and Fulham would be to turn our conversation on its head, and instead of getting a lawyer uncomfortably to opine on whether statute or contract is better, and saying that actually an assured tenancy is rather effective because of its contractual nature, could we reverse that thought process and make the secure tenancy a contractual one? And I certainly think it's worth the Commission's while reflecting very carefully on this. There is difficult case law which has the slightly odd result, in my view, in one respect, of requiring, even if a local authority doesn't want to have this discretion, to leave it able to vary the secure tenancy. You remember I said earlier that a local authority could vary. There is a decent reason also why it can't do so, because that would be regarded as fettering the discretion of the local authority. A local authority, one administration cannot, in ordinary circumstances, fetter how another elected administration goes about its business. Whereas, of course, a housing association which doesn't operate to the same rules, it may be, in some respects, as Clarissa has been guiding us, looking at matters perhaps from a rather more hard-nosed the commercial point of view, but nevertheless can be held to its bargain, its contract. The local authority can't be, because a local authority is a creature of statute, must act reasonably, and mustn't preempt what another administration might like to do in the future.
Sure, I think you want to come in.
Very quick question, legal question again. Does a secure tenancy give you an entitlement to secure tenancy in the property you're in, or only to some kind of secure tenancy? So in other words, can a council force you to move as long as they provide a secure tenancy somewhere else, or even out of borough, etc.?
It can only ask you to move if it establishes a ground for possession. It can't, in very short measure, I'm conscious of time, a secure tenancy is a tenancy of that property. Otherwise, Mike wouldn't be facing the issues he's facing at the moment with regard to under-occupation. If it was simply a matter of saying, don't worry, you will be a secure tenant somewhere else, but just no longer of the home you currently occupy.
So what the previous administration did was, because they were able to say there's a scheme, this development needs to go ahead, and that's why we now establish ground possession.
That's exactly it, and on the basis that I was describing earlier, a combination of ground 10, 10A, even a CPO, but in short measure, ground 10 or 10A, usually 10A.
Well, these are intriguing and important questions on which to end our proceedings. I think we will be coming back to these questions as we continue with our work over the next months. But in the meantime, can I say to Ian and Clarissa, really, very many thanks. This has been a fascinating session. All of our proceedings this morning have been very, very helpful and interesting indeed. It falls to me on these occasions, it says so on the agenda to do a summary, what it's suitable to do a summary of what we learned this morning. Let me say this. I think what we learned with regard to tenure is that there can, in principle, be no difference in rights. We've had the interesting but caveated observation that the contract can be stronger than secure tenancy.
It'll come back to what we
what we also learned from Clarissa is that practice varies between organisations, and a very great deal depends upon the values entrenched in the organisation. But also, equally from our earlier session, I think we have been powerfully reminded of the social context in which we operate, levels of debt, the opportunities to private renting, declining bedroom tax and benefit cap, in relation to under occupation, turnover in social housing, much slower than the past, because people are staying longer because of the difficulty finding affordable housing, and we heard these stunning statistics about the increasing demand for social housing in recent years. Homelessness acceptance is finally going down in a matter of 2 years. So this has been a very important session for us. We've learned a lot to ponder about on the part of both the Commission and those who have kindly attended with such patience and interest. We're grateful to our witnesses, we're grateful to our residents, and as ever, I'm grateful to my fellow Commissioners. Thank you all very much indeed. I declare this public hearing well and truly closed.